One more time. Good morning. Thanks, Todd, for leading us. My name's Carmel Martin. On behalf of the Center for American Progress, I'd like to welcome you to today's important discussion about promoting civil rights enforcement. I'm the Executive Vice President for Policy here at CAP. Today's event is focused on the infrastructure of equality, the mechanisms that we rely on to ensure that our nation's civil rights laws are fully implemented and available to all people. Much of our nation's progress has its roots in the laws we have developed to uphold our core values of equality and fairness. But too often, the mechanisms we have used to achieve this progress is taken for granted. Our commitment to equality, fairness, and equal justice under law must be more than lip service. It requires an unflinching and unwavering commitment to the tools and infrastructure needed to ensure that civil rights laws are implemented fairly and impartially and without regard to political interference. Many of these rights are under threat. Since the inauguration, the Trump administration has systematically taken or proposed steps to undermine or weaken civil rights enforcement. The Trump budget proposes cuts to the civil rights offices at the Departments of Justice, Education, and Health and Human Services. It also proposes the elimination of the Department of Labor's Office of Federal Contract Compliance Programs, which is responsible for ensuring that federal contractors who receive billions of dollars in federal funds comply with rules that prohibit discrimination in the workplace. The budget also proposes the elimination of the Office of Environmental Justice, which plays a critical role in protecting communities from chemical hazards and other environmental risks. The administration also has taken steps to erode hard-won protections. The Secretary of Education rescinded landmark guidance protecting the rights of transgender students. The President rescinded an executive order aimed at curbing chronic violators of labor laws from receiving federal contracts and providing for transparency in pay practices. And the Department of Justice switched sides in a lawsuit involving a Texas voter ID law, choosing to support a law designed to discriminate against minority voters in violation of the Voting Rights Act. These changes could have devastating consequences for American workers and families. We've assembled an insightful panel of experts to discuss these concerns and the steps needed to secure rigorous enforcement of the law in the future. The panel will be led by our own Jocelyn Fry, a senior fellow here with the CAP's Women's Initiative. Please join me in welcoming Jocelyn and our panel to the stage.
We wanted to talk a little bit about civil rights enforcement. Frequently people are quick to talk about how they're supportive of equal pay or voting rights or a litany of issues that we all sort of collectively say that we support and take for granted. But the reality is that we know that those laws and many other important civil rights laws don't get enforced by magic. And simply having the words on the page in and of itself isn't enough to make sure that the principles and ideas behind the laws are actually working in practice. And so we wanted to dig into that issue a little bit and talk about what is really needed to ensure that the civil rights laws we say we support are actually working and functioning and operating for all people. So we have assembled a really stellar panel of experts to discuss this issue in a little more detail. I'm going to introduce them alphabetically, even though they're not seated that way, and then we'll get started. Farthest to my right, Pam Kukos is an advisor and expert for many, many years with experience in equality issues, a range of equality issues. She's the founding principal of Working Ideal. And prior to that, she was a senior advisor at the Department of Labor's Office of Federal Contract Compliance Programs. She worked on a variety of enforcement issues and played a leadership role in developing their investigative guidelines around contractor pay systems. And prior to that, she was a counsel in a law firm and has a great deal of expertise in a variety of employment issues. So thank you, Pam, for being here. Todd Cox in the center is the Director of Policy at the NAACP Legal Defense and Educational Fund. He works on a variety of civil rights issues. Prior to doing a return stint to LDF, Todd was here, so welcome back.
Thank you.
He was the Director of Criminal Justice Policy here at CAP. And prior to that, he was in the Obama administration. He was the Director of the Office of Communications and Legislative Affairs at the EEOC. He also, in a prior life, worked at the Ford Foundation as a program officer, so he brings a range of perspectives and experiences. Thank you, Todd, for being here. Melvina Ford, sitting between Pam and Todd, is the Executive Director of the Equal Rights Center. She's responsible for the overall organization and management and strategic planning of the organization, works on a variety of civil rights issues and thinking sort of creatively and strategically about how you enforce civil rights laws. Prior to joining ERC, she was at the Department of Labor, and she worked as a policy counsel on enforcement and regulatory issues at the Wage and Hour Division. Thank you, Melvina, for being here. Seated immediately to my right, David Lopez is a partner at Outen and Golden, and he is the attorney in charge at the firm's DC office, and he's co-chair of the Discrimination and Retaliation Practice Group. Prior to joining the firm, he was the general counsel at the EEOC from 2010 to 2016. So he was the longest serving general counsel and was nominated twice by President Obama to serve in that position. As the head of the general counsel, he oversaw the agency's 15 regional attorneys and staff of more than 325 lawyers, and oversaw all of the litigation and appellate work of the EEOC. He also has served in other capacities at EEOC prior to becoming the general counsel. Thank you, David. Last, but I should also say David is significant because he's a law school classmate, so, so that's also important. And last but certainly not least, Laura Murphy, welcome Laura, is president of Laura Murphy and Associates. Laura has just a wealth of experience, has worked in a variety of capacities, and currently provides a lot of strategic advice and counseling on civil rights issues. She brings enormous experience on government and legislative matters. She was the director of the ACLU's legislative office for 17 years, where she advanced legislation on free speech, criminal justice, LGBT rights, reproductive rights, and many other issues. She's testified before Congress numerous times, and now she's providing a lot of advice, including working as a senior advisor to Airbnb, and she led a review process and a report that looked at discrimination issues that they were dealing with. She's also the 2015 recipient of the Hubert H. Humphrey Civil Rights Award from the Leadership Conference on Civil and Human Rights. Laura, thank you for being here. So you can see I could have talked for many more minutes about the biographical sketches of all of our panelists, but suffice to say we have a really wonderful group of people to sort of delve into this issue in a little more detail. So I want to start with you, David, because I think people use the term civil rights enforcement, and they sort of assume everybody understands what we're talking about. And so I wondered if you could talk a little bit about what that means in practice. You know, when you were at the EEOC and you got a case and sort of began to look at a matter, sort of how do you walk us a little bit through the process when you think of civil rights enforcement? What are the pieces of the puzzle to actually taking the law and making sure that it works for people in practice?
I'll walk through the nuts and bolts of the EEOC process, but I want to place it in a broader, more dynamic context, because we've all seen in terms of legal developments, really major developments that really have successively, in many cases, expanded rights and opportunities for people in the country. And I really want to kind of hone in on how that happens. When the Civil Rights Act of 1964 was passed, Roy Wilkins of the NAACP called it a Magna Carta of human rights. And if you think about it, what that act did is it really triggered a conversation in this country about the meaning of equal opportunity. It triggered a conversation in rooms such as this. It triggered a conversation around the dinner table. It triggered a conversation in classrooms. And it also triggered a conversation in the political sphere and in the courtroom. And most importantly, it triggered a conversation between the different branches of government, between the judicial branch, between the legislative branch, and between the executive branch. And through that conversation, you've seen some pretty amazing legal developments. Through that conversation, you see that no branch of government ever gets the last word. So when the executive branch took the position that the prohibition against sex discrimination covered pregnancy, the Supreme Court came in and said, no, we're not going to defer to that position. And then Congress came in and says, no, that's a correct position, and basically reverses the Supreme Court. So you have this ongoing conversation in so many different areas that's really produced a number of developments. It's produced developments such as the recognition now that pregnancy discrimination is part and parcel of sex discrimination. It's led to the recognition of hostile work environment. It's led to the recognition of disparate impact discrimination. It's led to the recognition of reasonable accommodation in religion through this whole conversation, right, between the different branches of government. So it's really important for me when I talk about my work at the EOC to recognize that we're just one part of that conversation, right? We're the executive branch, and we give our best reading to the law. And sometimes when we would interpret the law or take a position, there would be a lot of public outrage, like, oh, the EOC is overreaching, or the EOC's job is to apply the law, not to develop the law. But then you blink your eyes, and 5 years later, the EOC's positions have gained wide acceptance. So you look at the whole issue of sexual orientation coverage under Title VII. When the EOC took that position originally, the EOC was accused of overreach. Oh, the EOC is trying to push the law. All the courts have said that that's not covered. But slowly you see the position taking hold in the lower court. Slowly you see the position taking hold in the general public that of course, if you discriminate against someone based on sexual orientation, that's sex discrimination. So when we did our work at the EOC, it was always with that sort of broad focus that civil rights is a long game, that this is a long game, and the story never quite ends, okay? So we'd get a charge of discrimination. This is the nuts and bolts. A charge of discrimination from someone who believed they were discriminated against. There would be an investigation by our investigative staff. There would be an effort to determine whether there had been a legal violation. If we found a legal violation, then there would be a statutorily required effort to try to resolve the matter, informally and confidentially. If that didn't work, then sometimes, depending upon the issue, the case would come to the legal unit to make a determination of whether to litigate the case. But that determination of whether to litigate the case was often informed by our understanding of how the law should be applied in that particular factual situation. And remember, there are many examples of the courts taking one position, the executive taking another position, and at the end of the day, Congress taking yet a third position, right? So our job was to do the best we can in terms of interpreting the law. Sometimes we would win in court, sometimes we would not. But often what we would do is we would add to the conversation in terms of what discrimination meant and what equal opportunity meant. And again, I think one of the finest examples has to do with, well, there are two examples. The example of arresting convictions as disparate impact, which was something that was very controversial at the time, but which has gained deeper acceptance, I think, within the business community and broader society, but also the issue of sexual orientation coverage under Title VII. And that's all part of this conversation.
Thank you. That's helpful to have the big picture and then also some of the steps. So when you talk about sort of going from, first of all, that the agency is part of the executive that, plays one role, but then you're talking about, you get the charge, you assess it, you've got investigators, then you maybe go through a legal process. It's a robust operation, right?
It's a dynamic operation.
very much so. And across many different regions of the country, you get at the EEOC claims across the entire United States. And people often kid me because I know many different anniversaries. So one of the anniversaries sometimes that other people don't know. So one of those anniversaries is this year. It's the 40th anniversary of the Equal Employment Opportunity Act. And that law is significant for the EEOC because it actually, a few years after the Civil Rights Act, gave the EEOC litigation authority. Can you talk a little bit about why that was important? Why was it significant to give the office that you ran litigation authority?
I think it was significant because it enabled us to present our positions in federal courts as a party. Prior to that, the EEOC was able to present its positions as amicus, but to bring a case as a party gave us particular influence in terms of shaping and developing the law. Justice Thomas, in his dissent in the Inclusive Communities case, which was the one that recognized disparate impact in the housing context, went on a long screed about how the EEOC fabricated this whole idea of disparate impact out of whole cloth, and it was an illegitimate position, and it wasn't a position that was linked in the statute. Now, of course, he ignores that disparate impact was codified by Congress, and he ignores the fact that the Supreme Court recognized disparate impact in a unanimous decision. But what he highlights is that the EEOC, prior to litigation, was able to use the bully pulpit to press an issue and press an understanding of discrimination as systemic. But that only took you so far. Once the EEOC was able to get litigation authority, we were able to push those ideas dealing with disparate impact or with hostile work environment, or that pregnancy was part and parcel of sex discrimination in the federal courts, and try to develop the law in the federal courts in public, right? It's very important. This was all done in public so that the public would be educated as to the rights and responsibilities, and that if a court ruled adverse to our position, that Congress would see that, and Congress would have the opportunity to correct it and move in a different direction.
And just for some folks in the audience, so explain what disparate impact is. What's a disparate impact case?
Disparate impact is a theory of discrimination that looks at discrimination as essentially systemic. So what it does is it looks at selection criteria and asks two questions. And so much of the political focus has been on the first question, but the second one is really in some ways the most important one. The first question is, does that criteria have an adverse impact on a protected group? So, for instance, when you look at arrest and conviction screens, you ask the question, does a screen have adverse impact on the African American community or on the Latino community? But then the second question is, if it does have an adverse impact, does it relate to anything having to do with the job? Is it job related and consistent with business necessity? Or is it just something that excludes people of a protected group, but doesn't have any relationship at all to the job in terms of measuring performance, in terms of assessing safety in the workplace? So it's really always important to keep your focus on both questions, but the second question is very important. Does it have anything to do with anything, right? And if it doesn't, why should an employer be permitted, an employer in fact is not permitted, to have selection criteria that are going to have an exclusionary effect on certain protected groups?
Okay, great, thank you. So you helped us sort of set the stage a little bit in terms of thinking about what are the different components of civil rights enforcement when we talk about it. What is it that we're talking about it from a structural perspective? What does it look like in terms of the actual operation? Todd, I want to bring you in to get your perspective. When you think about civil rights enforcement, both from your EEOC experience, but also now from an LDF perspective, what are the things that you are looking for? What is it that you're looking for when people say that they have a sound, robust investment in civil rights enforcement?
Sure, and thank you for allowing us to participate in this important discussion. I think, the first thing, and I'm going to put this in terms of thinking about policymakers and decision makers, right? So if I'm talking to a member of Congress and they're telling me that they're interested in a robust civil rights enforcement regime, I want to find out what their capacity or interest is in actually funding the operation, right? So, the appropriations process, the budgetary process is really the roadmap for, number one, how you fund the government, but also a roadmap or an extension of your policy priorities. So we see in this administration, as Carmel laid out, some very stark, draconian visions for civil rights enforcement. That needs to be interpreted by Congress, and you would hope Congress would say, we have a different vision, or we have another vision, and they'll lay out a roadmap, a funding roadmap that will actually fund those particular tools, that particular infrastructure that we consider important for civil rights enforcement. So that's number one. Number two, again, thinking in terms of Congress, you want to make sure that once they do that funding, again, thinking like a funder, some follow-up. We call it oversight. So we want to make sure that there's sincere interest in making sure that, for example, if Jeff Sessions is given all this money to enforce laws and be a law and order attorney general, he's enforcing all the laws, including civil rights laws. Bring him in, have a conversation about that. And we want to see oversight. And I have to say, there was a time, as David alluded to, where this was a bipartisan effort. The Civil Rights Act of 1964, the Civil Rights Act of 1991, the Voting Rights Act, all of these statutes, there was some sort of norm that I think across the party lines everyone agreed to. And I think we're obviously slipping away, unfortunately. But we want to see some oversight. And then finally, I think we want to make sure that the executive branch or whoever's enforcing these laws have two things. First, a commitment to the rule of law. Imagine that I have to actually articulate that, a commitment to the rule of law, that laws matter and that norms matter. But the second thing I think that's important is an understanding of again, thinking in terms of the federal government, the federal role in making sure these things happen. So again, that's in short supply now. So we have a Secretary of Education, for example, who's not really willing to unequivocally state that money given to a private school, federal money given to a private school, the students in that school are entitled to protections of federal civil rights laws. And so I think that understanding the federal role, not shying away from it, not abstaining from it, is another important aspect to all of this as well.
Thank you. So that helps us in terms of thinking through what are the steps, what are the pieces that we need to look to. I want you to talk a little bit about voting rights.
Sure.
Another anniversary this week was the fourth anniversary of the Shelby versus Holder decision. Made serious dents into enforcement of the Voting Rights Act. LDF has a long history in this space. Can you talk a little bit about what you think is needed for sound and strong, vigorous enforcement around voting rights? The president talks a lot about voter fraud with a series of alternative facts, but maybe you can give us your perspective on that issue and what we really need to be doing to ensure that we have sound voting rights for all Americans.
Sure. Well, I think you touched on it. Shelby versus Holder was a watershed decision. I mean, we use that term almost in a cliche way these days, but it really was. It opened the door to, it really unleashed voter suppression in this country. So just to back up, before Shelby, there was a part of the Voting Rights Act called Section 5, and what triggered Section 5 enforcement was Section 4. But Section 5 essentially said that if you have a jurisdiction that has a long history of discrimination in voting, and most of those jurisdictions were in the South, but New York was part of that. California was on that list. You had to submit any voting change that you had, redistricting, moving a polling place, anything, to either the Department of Justice for administrative review or to the District Court for the District of Columbia here in D.C. to have an assessment made to make sure that that change was not going to be discriminatory in effect or intent. Shelby took that away. In the wake of that, something like 14 states, some of whom were once covered by Section 5, instituted broad, sweeping voter suppression tactics right after Shelby was instituted. So North Carolina instituted its photo ID law. For the presidential election, they eliminated or closed polling places, seriatim, just closed them before the election, which is anathema to happen right before an election to sow confusion into the electoral process. Texas, which is sort of a serial Voting Rights Act violator, instituted its own photo ID law, which Carmel alluded to. Other states instituted those kinds of suppression methods as well. And in fact, the 2016 presidential election was the first presidential election in 50 years that occurred without the full force or the full effect of the Voting Rights Act because it had been so weakened. So that sets the stage for, as Jocelyn mentioned, Congress to take further action to undermine the Voting Rights Act or undermine voting rights. And we can talk more about that. States taking further steps to undermine voting to eliminate opportunities. And now we have a president who a president who won the election, by the way, who has said he could have won even more, I guess, or demonstrated how much more he could have been successful if he only won the popular vote, if certain illegals had not voted, or certain people from certain neighborhoods were not bussed into jurisdictions to vote, sort of raising the specter of voter suppression, which we know from our own history at LDF is a proxy for voter suppression. It's sort of a dog whistle to those who want to suppress the votes, not just of everyone, but of certain people who they perceive to be threats to their particular political interests or interests, period. And to follow up with those allegations, which are unfounded, and we know from a lot of research that you're more likely to be struck by lightning than to experience voter fraud. And it's so unusual that we don't have a lot of prosecutions. And this is someone who worked for Legal Defense Fund, and we defended folks who were accused of voting rights violations and voter fraud violations. So on top of that, he's now called for a commission led by Vice President Pence and Chris Kobach, who's the Secretary of State of Kansas, who is the only one who truly seems to believe that there's voter fraud out there without any evidence. And they are putting this commission together, and they're going to, no doubt, have findings created saying that there's actually voter fraud. Now, why is that a concern? Well, our Attorney General, who would be enforcing whatever they find, is someone who we, as the Legal Defense Fund, had to defend against, who brought trumped-up voter fraud allegations to prosecute 3 African-American voting rights activists in the South. Those allegations were proven to be unfounded, thrown out of court, but the damage done in the course of that, hauling these folks in buses miles into courtrooms to be interrogated, to be investigated, that's what we're talking about here. That's what this commission potentially might do, and that's the worry. We're also worried about any of these trumped-up allegations being used for potential prosecutions, or at the very least, investigations that suppress and chill voter opportunity. What do we need? Well, we need partners, as we had in other jurisdictions, other administrations across party lines. So in the last administration, for example, in the wake of Shelby, they said, you know what, we still think Section 2 of the Voting Rights Act, which allows to bring, as David put, disparate impact cases under the Voting Rights Act, we think that's going to be a useful tool. So we're going to go ahead and continue to do that. And we're going to use the NVRA in a way to still push forward and expand opportunity. We're not talking about just defending, but expanding opportunity for voting rights. They were real partners. They litigated with us and the Lawyers Committee the Texas ID case. So we, as partners, litigated and sued the state of Texas, saying that their plan had a disparate impact, as David put, for employment. It also was riddled with intent to discriminate. And Texas, by the way, I think, I'm not speaking out of turn here, I don't think they've had a redistricting plan that they've enacted that has not been found to be, has some level of discriminatory intent connected to it. So this photo ID case is critical. What did Jeff Sessions do? As we flew down to make the argument regarding intent, they switched sides. They said, you know, we're no longer going to defend that. Why is that important? Well, all we have left after Section 5's removal, as was talked about before, is Section 2, which allows us to bring these affirmative cases. But also, there's a part called Section 3 that allows us to say that if you're a jurisdiction found to have intentionally discriminated in terms of voting, we're going to bring you back under coverage. So if Texas is found, as it has been, to be have actually instituted its photo ID regime with intent, it can now be reviewed by the Department of Justice and the courts to make sure that any future action that they take is not discriminatory. So these are all very important pieces, and it's very important and critical that a Department of Justice or any governmental regime understands, respects the rule of law, but then also works with us as partners to make sure that we're not backtracking on our voting rights.
Yeah, thank you. That's really helpful to put some of this into context. So both you and David talked about both sort of the actual infrastructure. You know, how do you actually make sure that these laws actually work for folks, and what do we need in terms of funding and staffing and investigatory tools. But you really raised an important point that even with that, that you have to have a commitment to sort of the spirit of the law, and that, there are different aspects of the law that, provide different benefits, and the Voting Rights Act is a good example of that, particularly when the courts sort of take one piece of it and make it ineffectual, and really erode sort of the protections that are offered. Pam, I want to bring you into the conversation because we've talked a lot about EEOC, but the other place, one of the other places in the federal government that does a significant amount of important civil rights enforcement is the Department of Labor, and particularly the Office of Federal Contract Compliance Programs. And OFCCP, which is the acronym, doesn't get as much visibility, tends not to be an agency that people know as well, but it really plays a critical role. So I wonder if you could talk a little bit about why that agency is important. And then the follow-up I'm going to ask you, and I'm going to pull in David in a minute, is to talk about the proposal that Carmel mentioned, which was the notion of consolidating or eliminating OFCCP and sort of folding those functions into EEOC.
Sure. Good morning. So the federal government buys a lot of stuff, right? Buys missiles, buys paper and computers, constructs federal office buildings and courthouses, spends a lot of our money, right? That's our money, that's our tax dollars. And so the idea of the OFCCP is that we should make sure those tax dollars go to companies that have fair employment practices, right? And if we want to do the history piece a little bit, since we started that this morning, right, this has its origins during World War II, FDR issued an executive order and ordered that the federal wartime defense contracts, right, that those companies could not discriminate against African Americans for those really good, important jobs. And so that was actually after a huge organizing effort by Philip Randolph and others to put pressure on the government to do that. But the idea was that equal opportunity, this is a way that the federal government can actually have a big impact by deciding how its money gets spent. The current OCCP goes in and does audits of contractors to make sure they're following the rules. And not just this floor of not discriminating, and now that discrimination extends to much more broadly. So race and ethnicity, but also sex discrimination, sexual orientation and gender identity, veterans, people with disabilities, religion. I'm sure I've forgotten one. And so the OCCP goes in and make sure they meet that center of no discrimination, but also that they are affirmatively making sure their process offers a level playing field, right? Are you recruiting really broadly? Are you making sure that the way that you run your workplace is fair and equitable? And OCCP does that by getting a bunch of data and documents and reviewing them, and sometimes going to those locations and interviewing people and trying to just make sure that everything is on the up and up. And that's really important because workers don't always know that they've been discriminated against. They don't know. They'll only go and talk to OCCP if they've kind of figured out something's wrong. But I found in my private practice that my clients might say to me, I thought it was me, right? I thought there's something wrong with me, that I didn't get the promotion or I didn't get hired. But then I saw the other people who looked like me, who I knew were really talented, and they also didn't get that promotion. And then I thought, well, maybe it wasn't me. But lots of people never even get to that second step. And so this agency can go in and look where no one's even complained yet.
And talk a little bit about why that function is different than what EEOC does.
Sure. So, primarily it's the idea that you start kind of from different standpoints, right? So one is whether you're primarily an agency that takes complaints from the public, right? Or an agency that goes in and does these kind of audits and reviews. The second question is kind of what's the objective, right? In all cases, the objective is to make sure that these workplaces are fair and equitable, but the OFCCP's framework is very oriented towards those contracts. And so at the end of the day, if you mess up, right, what's the consequence? Well, OCCP can get back pay for workers and some reforms, but the major thing is that they can essentially say you can't get any more contracts, right? So that's a very unique and important lever to make sure that those rules get enforced. And you know, the one thing that we're learning, we have lots of good research now that says that it's not enough to have a policy, right? That can just be symbolic compliance. Like, yeah, we don't discriminate. What you need is to have an accountability mechanism. You need to have a way to make sure that folks know they might get checked up on. And so these audits provide that accountability. And we have some pretty good research that says that that actually works, that the companies that are under those rules actually tend to perform better than companies that aren't.
So it's sort of extending enforcement in a different way, that you have sort of this affirmative ability to go on site and actually sort of evaluate, you know, whether employers are sort of doing what they say that they're doing. And it's sort of an extension of enforcement in a slightly different way than what EEOC does.
But I want to say, like, the public-facing function of the EEOC is also critical, right? People need to have a place to go, and sort of well-trained people to help them figure out what's going on, and an agency that's going to go in and be on their side, you know, in this very direct and affirmative way. So they're complementary and very different strategies.
Right. I think that that's an important distinction. I'm going to ask you and David about the idea of consolidating and what that would do as a practical matter. But before I do, Laura, I want to bring you into this conversation a little bit because you've had a lot of experience working on many of the issues that folks have raised thus far about ensuring sound civil rights enforcement, going up to the Hill, talking about the funding and the commitment to actually implement, making sure that or agencies have the resources to actually implement the law. But you also advise companies. And so I want to get your perspective on, you know, looking at this from a sort of a business perspective and how they view civil rights enforcement. And what do you say to companies who are, you know, I hear people talk who are nervous about it or reticent about it or concerned about it or see it as a bad thing. You know, what do you say to companies about, you know, promoting sort of strong enforcement internally and being supportive of robust enforcement efforts externally?
Well, I think it's, thank you for having me on the panel. I think it's the big problem with corporations, especially young corporations and people in the tech world, is that they often don't know anything about civil rights. They start their companies because they're great engineers, or you know, they've got this laser focus on money-making apps and that sort of thing. But the average person does not have a grounding in our Bill of Rights and Constitution and in our civil rights laws. So you know, if I passed out pieces of paper to this crowd and said, okay, I'm going to give you a test, you know, name all the civil rights acts, you know, people would be queasy, and I assume I'm talking to a very well-educated audience. And so the challenge I see is that there's a lack of awareness, and there aren't places for these leaders, corporate leaders, to go to figure out what they need to do to comply with civil rights enforcement. I was fortunate in working with Airbnb that the leadership really did not want an environment where discrimination took place, and so the commitment started from the top. But some of you all have probably recently read about some sharing company, you know, sharing economy companies who did not have that leadership from the top. And so there, I think the first fear and concern that corporations have is, are we going to be sued? Are we going to be sued for employment discrimination or some other civil rights violation? You know, will it be around race? Will it be around gender? Will it be around disability? So their interest is in staving off lawsuits. And when I came to Airbnb, which is one of the companies I can talk about more openly, they were looking at a possible litigation environment because some of their customers had complained that they were not able to book listings because they believed their photograph made it far more likely that they were victims of racial discrimination, and they had a white friend who booked the same listing and they got through and were able to get it. So I think in advising them in particular, I looked at all of the public accommodations litigation and all of the fair housing litigation and what the settlements look like. And I said, look, instead of being sued to make these changes, why don't you proactively accept that you're going to train your employees, you're going to have a strong anti-discrimination policy that's rigorously enforced, that you're going to diversify your leadership and your workforce, that you will engage in more diverse contracting opportunities. And after a 3-month conversation, Airbnb publicly agreed to do all of those things. And I basically, said, what you're doing is good for business. It's not because it's the right thing to do. Just because it's the right thing to do. We are in a much more diverse society than ever before. Over 50% of the children born are racial minorities. By the year 2040, there will not be any single racial majority group in the United States. And if you're looking at market share, you will perform better if you have a robust civil rights enforcement strategy in-house. And there is a lot of research coming out of the Harvard Business School, the Stanford Business School, that shows that companies that are more diverse and proactively embrace civil rights are performing better in the stock market. And so finally, one of the things I will say about civil rights enforcement is that because the federal government in the near term is not likely to go after corporations and say, you must engage in more equal opportunity in hiring and contracting, it's not going to likely happen. What I did was I insisted that the company continually meet with civil rights leaders as a condition of my forward engagement, because there needed to be checks and balances on what they did. So I'm coming up with a new approach for corporations that are open to it, of stepping into civil rights as opposed to resisting. But first, we have to understand that a lot of corporations just aren't focused on it, may be well-meaning, but have no one in their company who understands what the laws are, much less compliance officers.
Thank you. That is helpful, and it's helpful to have that perspective. And I'm gonna pull in Melvina, but the thing I want to come back to you on is with this notion of stepping into civil rights. What do you say to companies at this moment when it feels so antagonistic? We have so much hostility. There's data that shows the rise in hate crimes. We have this, very caustic political environment, and, companies who want to do the right thing, who may have workforces where, feelings are raw. I've read stories about people, they get into fights over, who won the election and a whole set of issues. What do you say about, trying to make sure that you create a workforce and a work environment that's conducive to, sort of just being able to be productive and work together? So I'm going to come back to that question. I'm just going to tee it up. Melvina, I want to bring you in last but not least and get your perspective on enforcement. You've heard folks talk a little bit about here's what the agencies do, here's the role that they play, and we've talked a little bit about the structure needed to make sure that they do the job that they need. We get a little bit of the business perspective. You come at this from a different perspective, and talk a little bit about your work and about sort of surfacing. I'm particularly interested in surfacing different types of discrimination, including areas where we might not ordinarily be focused.
So the Equal Rights Center does this unique thing called civil rights testing testing is not a new thing. It's been around since 1950s and sanctioned by the Supreme Court. Most people know about kind of secret or mystery shopping, where you might send somebody into a restaurant and they're there to evaluate the quality of the service or the food. Testing is kind of similar in that respect, except we've got trained testers that we will send into an establishment, usually in a matched pair. So if we're trying to uncover whether race discrimination is happening, for example, we'll send in a white tester and a black tester. They'll be very well trained and scripted. They'll have very similar qualifications, and we'll see how their interaction goes. So for example, we recently completed an investigation in the criminal record space, which we have to pay homage to the EEOC and OFCCP and HUD for the work that they did really surfacing this issue of barriers for people with criminal records when they're coming back into society and their ability to get housing or gain employment. So we created an investigative project where we sent white testers with a criminal record and black testers with a criminal record out to try and secure rental housing. And what we did a bit differently in this investigation was we used women, because there's been a lot of talk about African American men and their ability to re-enter. Not a lot of talk about African American women. So we wanted to get a sense of what was happening to that group when they were going out trying to seek housing. And we found that in 47% of those interactions with housing providers, the white woman with a criminal record was actually favored. Now, not all of those interactions were legally actionable, but some of the more surprising results were when the black woman would go in with a criminal record and be just turned away, and the white woman with the criminal record, the housing provider would say, well, we can't let you apply for this particular property, but let me help you find other places where you can find a place to live. So that's the sort of thing that we were seeing in that particular study. And what's really interesting about the ERC's work is we can do these kind of audits and studies in this space and generate larger amounts of data, but that data also allows us to target more specifically companies that we see are having issues, and to do follow-up testing with them, to then reach out to those companies, let them know, look, you've got this problem, we're seeing it on your front line, because to someone's point, companies can have high-level policies, but if your frontline staff isn't implementing or following those policies, one, it'll get you into trouble, but two, you're turning away potential customers, right? So we'll go to them, we'll try and figure out if we can get them to kind of fix their issues, as Laura does in terms of advising them. And then if they don't, the ERC, if need be, will sue them as an organizational plaintiff. One of the great things about the EEOC, as David talked about, is their ability to bring EEOC litigation as a plaintiff. And so the ERC really focuses on, can we bring an organizational lawsuit if we can't get the company to fix its practices? And the reason why that's important is because if I'm a black woman and I am a black woman, I have a criminal record, and I'm going out and I'm applying for housing, to Paula's point, I don't know that I'm being discriminated against. I don't know who ultimately gets that apartment. Same with if you're applying for a job, I don't know who ultimately, gets that job. So I don't have that information. And if I have a criminal record, what's the likelihood that I have the resources, even if I figure out there's a problem, to do anything about it? So the EERC really tries to stand in their place and see if there is a particular problem, if we can bring a suit, as a plaintiff. But as a part of that, oftentimes we are reaching out to companies and saying, look, because people don't believe they have a problem until they see it. I mean, we live in the generation of it didn't happen unless it's on videotape, sort of thing. So making sure that companies get educated about this is what's really happening on the front lines of your company, and we're giving you an opportunity to fix it.
And are there tools or strategies that you use that you consider more cutting edge? You spoke about the testing work. That's really important work. There have been opportunities off and on in the administration. Various administrations have thought about that, but have encountered difficulties. Are there tools that you think are really sort of cutting edge that we ought to be thinking about?
So obviously more transactions are moving online. So a lot of our testing now is actually starting to move online. We're starting to have conversations really with some academic institutions about within the tech space, because I believe that the tech community really can be a leader in this space. And the one thing that's missing, and Laura kind of pointed to this, is we really do need more robust partnerships between the tech community and the civil rights organizations, because we're having conversations with people about how do you build scrapers, for example, so that you can deploy programs on the web and you can better identify when discrimination is happening in online communities, because testing, it's not just going to a housing provider on the ground now. You want to be able to look at ads on Craigslist, but there's millions and millions of ads on Craigslist, right? So we have to be able to target our resources more efficiently. We're also using mapping software so that we can better target neighborhoods where we see things happening. We're also looking for kind of public data sets, and the Obama administration was really leading the way in terms of taking government data and making it public and transparent and putting it online. And obviously we're seeing reversals in that space. But I do believe that another potential partnership is with academic institutions who are very well resourced and have the ability to generate a lot of public data. And so we're looking at those sorts of public online data sets. But we're just scratching the surface of what needs to be happening in the tech space in testing. When you start to look at big data and how that's influencing decisions, you look at artificial intelligence, which I'm a former employment litigator, I know nothing about, but I look at it with fascination when they say that artificial intelligence is designed to learn from us, which means it's going to pick up all of the biases that we have. And there are folks in the tech community that are doing some phenomenal work in the AI space. And what we need to do is start connecting those people with the folks in the civil rights community so we can develop a lot of those kind of high-tech tools.
Thank you. That's a great segue into a conversation about tools and specific tools that we think are valuable and important. And I want to couple that conversation with threats. What do we think is at risk at this particular moment? So I want to talk, Pam and David, I want to talk to you a little bit about the idea of consolidating EEOC and OFCCP and the threat of doing that. But first, David, I want to talk a little bit about tools you used at EEOC. And particularly, there's a lot of interest in equal pay. And one of the things that was done during the Obama administration was a tool to collect more pay data, the EEO-1 form. The EEO-1 form has a long history, a very long history that goes to the roots of the agency. And so I'd love for you to talk a little bit about using that tool and the importance of that tool and the potential risks of losing that tool, the opportunity to gather pay data through that tool.
Yes. I think most of you may remember that the first piece of legislation that President Obama signed was the Lilly Ledbetter Fair Pay Act. And for some reason, I don't know what happened with that particular act, but that was the end of bipartisanship. Because up to that point, every civil rights act had been passed on a bipartisan basis, but suddenly, that one wasn't bipartisan. And that one was an extremely partisan act in terms of the final vote. President Obama put fair pay, equal pay for equal work, really at the center of his domestic agenda. It was a very important part of what he did, and I think there was a recognition of the complexity of the issue and the intractability of the problem. And so one of the things that emerged out of the Obama administration was a proposal to update what is known as an EEO-1 tool. This is a tool that employers are required to fill out that up to that point would really identify how many people in each racial group, national origin group, and by gender they had in the different job positions. And what the Obama administration did is it required that tool also start breaking down, requiring employers to break down how many men and women are in various job classifications and various pay bands. So that was a very important tool both for an enforcement purpose in terms of sort of getting a thumbnail sketch for the enforcement agencies, both the OFCCP and the EOC, to determine, not necessarily to prove, right? Because it may not have been sufficient to prove, but to see if there was a problem. Because if you eyeball something and you see, hey, wait a second, all the men are in this pay band and the women are in this pay band, it's like the old song set goes, things that make you go, and it's sort of a green light to make you continue to look. But it also provides, and this is very, very important about so many of these tools, it helps employers look in the mirror and do some self-monitoring in terms of what they are doing, okay, in terms of this issue. It helps them enforce themselves because the data is there, but often people don't want to look at it, okay? Often people don't want to analyze it, and this sort of forces the employer community, those over 100 employees, to really look at that information. So needless to say, like just about every civil rights initiative out of the Obama administration, this one triggered a lot of blowback, a lot of controversy in the business community about cost. And this is one of those enforcement tools that, you know, like it or not, elections may have consequences. It's not clear what is going to happen with that particular tool. Right now, the EEOC is comprised of 3 Democrats and 1 Republican. But one of the Democrat terms is ending, and at some point there's going to be 3 Republicans on the commission. And I think that the expectation is that that tool will be either eliminated or modified. I think the best thinking now is that we may be in a sort of mend it, don't end it space in terms of what happens with that, but it's hard to tell. So, you know, that was something that just, that was a product of an enormous amount of thought, partnership with the nonprofit community, the advocacy community, the academic community, and it really right now is being threatened. The good news is, and I think we've seen this throughout, I think we've seen this since January, is that many states are really jumping into this space and being very aggressive, both in terms of litigating against the federal government for these efforts to roll back the clock, but also in terms of developing, you know, really kind of pioneering state statutes, particularly I think in the area of pay discrimination, where, you know, states such as California and Massachusetts are really pushing the ball forward. And to the extent that you have these national corporations working in one state and being subject to the requirements of, you know, these states that have been very forward-looking, you know, they really have 2 choices, either a uniform national policy or to try to comply with the patchwork of state policies across the country.
Thank you. That, you know, that is helpful, and it's important to sort of put that out there that that, you know, we're in sort of uncharted territory at the moment. The EEO1 tool, though, is a tool that you used. I mean, you're in the general counsel's office, you know, in investigations and litigation. It's one of the tools, along with many others, that you use just to move your cases forward.
Yes, of course.
Okay,
Yeah.
absolutely. I want to get your opinion and Pam's thoughts on the idea of consolidating offices. Now, you know, as I, you know, obviously, one never completely knows what the administration is thinking, but certainly the idea of essentially eliminating OFCCP and over 300, you know, staff and consolidating those functions into EEOC. It is one of the rare areas where there has been, I think, actually significant bipartisan opposition to that concept, actually, I think for a variety of reasons. But I wonder if you could both quickly speak to that idea of why, you know, is it a good idea, what it would mean from a civil rights enforcement perspective. I'll start with you, Pam.
Sure. So it's basically like saying, well, you know, the Federal Trade Commission regulates business fraud and conduct, and the Securities and Exchange Commission regulates business fraudulent conduct. So maybe we should just make them one agency, but they do different things. They have different laws, they have different tools. And so it's either means you make them not work as well as they do now, right? Or you actually have to spend a lot more money to make that new entity do everything that the old entities were doing. And so it's just kind of stupid, I think, to be honest. Which is why you see a lot of people scratching their heads and saying, you know, maybe this, you know, just wasn't very well thought out.
David, do you have thoughts on it?
I think the advocacy community has opposed it, and the business community has opposed it by and large, which is a very, I think, a curious alignment. You know, I think really, you know, the central question is if this happens, and I think most people now think it's probably not going to happen, but we'll see. If it happens, it's absolutely imperative that the resources come over with the OFCCP, because OFCCP does stuff that the EEOC does not do. It has capacity that the EEOC currently does not have, right? So it's really important that the resources, and that includes the human resources, you know, are able to come over with the program in really the same force. Looking at the budget projections, it doesn't look like that's what's anticipated. It looks like there'll be a consolidation and a cut in the budget. So it looks a little bit like a sleight of the hand to get the OFCCP. But it's really important, as Todd mentioned, to really look at the budget implications. You know, there are certain things that the EOC does in, you know, just coming from the agency. You know, I think the OFCCP would love to have subpoena authority. So the EOC does have subpoena authority. And maybe that's why the business community is opposing it, because I think that there are many opportunities. Certainly we saw many opportunities to kind of consolidate the information and come up with synergies, enforcement synergies to really, you know, sock it to the bad guy. And so I'm suspecting that's what the business community is concerned about. But right now it looks like what's happening is that the expectation is that if this happens, it would not be with the same resources, and actually you would probably need more resources, because you need the resources to make sure that the marriage and the consolidation works, and that's going to take, I think, enormous administrative and transactional costs. Not a well thought through idea.
Thank you. Well, you know, but you raised an important point about sort of what people understand about actually enforcement and how it works, and the implications of these ideas. Todd, you know, I know you recently testified before the House and Workforce Committee on some of these issues. And I guess, you know, one question that I have is that, you know, back where we started, which is that everybody says they're for civil rights enforcement, right? Like nobody says I'm against equal pay, or I'm against voting rights. But there seems to be, well, okay, so let me
It's a new abnormal.
backtrack. You know, but there seems to be, you know, the polite word is a disconnect between the rhetoric and then sort of the reality, and the willingness of, as you pointed out, putting the funding and the resources. Do you think it is a misunderstanding? Like, do you think that people don't understand, you know, there's all this infrastructure, there's, you know, all these mechanisms that you need to support if you really support civil rights, or or is there just something else going on?
Well, I think, you know, to Laura's point, I do think there are, and that's why we have compliance officers, that's why we have employment lawyers that don't just litigate but work with companies to help them understand what the laws are. There are companies that actually genuinely want to go about and do their business but not violate, you know, the EPA rules, regulations, the Civil Rights Act, and the like, and so they go about trying to comply. I was in the private sector. I think businesses by and large want to do their business. I do, however, think that some of this disconnect is disingenuous. I think that, again, you know, talking about my experiences at LDF and the many years doing policy work, I think there are overwhelmingly very powerful forces influencing Congress and decision makers, lifting up falsehoods about the burdens that civil rights enforcement places on these companies. And, you know, I think I contrast that with what we saw in Fisher and other affirmative action cases where companies filed amicus briefs saying, oh no, we think diversity is great. And we're smart enough to know that if we have diverse workforces, as Laura mentioned, we're going to make more money. I think, though, that's the companies. I think there are people who are working on behalf of companies, perhaps here in DC, that are sowing seeds of fear about EEOC, law enforcement, civil rights law enforcement, how it's going to be overly burdensome, how EEOC is overreaching, citing 4 or 5 cases out of hundreds and hundreds and hundreds. Saying that the EEO-1 form is misguided and just poorly done, and therefore we shouldn't comply with it. I think sowing those seeds of fear in the corporate world, but also with Congress, is really sort of a proxy or a backdoor way of saying we just simply don't want to comply with these mandates. And I think that, I think we should remember, there are a lot of anniversaries. There's the Cheney, Schwerner, Goodman anniversary, which was just last week. Civil rights activists who died for voting rights. I think that we need to just remember where these mandates came from. Brown, perhaps the genesis of all of it, is still good law. The court has seen fit not to overturn it. The Civil Rights Act of 1964, 91, still good law. Congress has not done away with it. And I think that when companies are saying, we don't want to file these EEO-1 forms, we don't want to comply with these mandates, what they're really saying is that we don't want to comply with Brown. Let's just call it what it is. We don't want to comply with these mandates, which are actually still good law. And so I think we should separate the conversation. If you think Brown is wrongly decided, if you think that the Civil Rights Act of 1964 is should no longer be complied with, let's have that conversation. I would be happy to sit down with any company and have that conversation. But don't backdoor your way into noncompliance. These are mandates, just like you're mandated not to blow up a car that you've manufactured driving down the road. That's bad business. You should be mandated to understand that you should also comply with the Civil Rights Act. And it shouldn't just be that we're commoditizing rights, that is good business. That's true. But these are mandates, and it shouldn't just be a decision that's a cost-benefit analysis. These are mandates. They're not optional. And so when I hear arguments about the burden on business, I have to ask, what's the real burden here? The burden is complying at all. And I think separating out genuine misunderstanding with this sort of proxy, disingenuous desire just not to comply is critically important.
Thank you. I think that those distinctions are important, and it really pushes us to think hard about how we actualize our commitment to principles that we all say that we ascribe to. But you talked about fear, and so I want to loop back to both David and Laura, particularly from a business perspective, but I think truthfully you are speaking to fear in a broader context, because I think fear manifests itself in different ways. But one of the ways that it has come up, I think, these days is, given the current environment and the current climate. And I think businesses who want to do the right thing are sort of struggling with trying to figure out, what do I do these days? How do I not squelch free speech, but at the same time create an environment where people feel that they can express themselves, but also not feel like they're hostile? Businesses who want to be proactive, but also don't want to, get sued about something. So, I'm curious about, both of you work with clients. Both of you have clients come up and ask you questions, about, what to do. And I'll start with you, Laura. I mean, what do you say to folks about, as you say, stepping into civil rights and taking a different approach?
I think that there's a cause for optimism. I think that companies need to look at their market, who are their users, and also their employees. Companies that embrace employee affinity groups, like the disability workers will have a group, the LGBTQ will have a group, African Americans, Latinos. Those groups are important bellwethers to employers about what is needed in the civil rights arena within the company. The second thing I would say is, look at the Women's March. Look at the campaigns lodged against Fox advertisers around the Bill O'Reilly stuff. The millennials have power. Now, I wish the millennials would vote in greater number, but they are saying to corporate America, notwithstanding what's going on with Donald Trump and the Congress, we want to have a voice, and and corporations, if you don't listen to us, we're going to walk with our feet. Look at the Uber boycott. Look at how the head of Uber and the head of Tesla were decided to get off of the president's economic advisory boards because their customers spoke to them. And Fox was not about their dislike of Bill O'Reilly. Fox was about their advertisers, right? And so they had to satisfy the concerns of their advertisers. So I do think we can talk about government agencies and Congress all we want, but the people still have a lot of power in this country. And in order to make civil rights real, you have to have organized constituencies inside the company, outside of the company, and if the federal government falls down on its job, that's not the end of the story as far as I'm concerned.
That's great, I think, and great advice to folks. David, in your experience, and I should say that we're going to have time for a couple of questions, so I want people to start thinking about if they have questions. Your clients, do they only come to you when they have a problem, or are increasingly folks thinking sort of more proactively?
Well, I think you need to understand, my firm is a worker side law firm. So when they come to us, they have a problem with some of these companies that have discriminated against. So we do civil rights enforcement, we do worker side work. And so usually as plaintiffs, they come to me when they have a problem, when they're facing discrimination, when they're about to be terminated or have been terminated, or they identify some big structural class action type barrier. But I think I want to sort of pick up on Laura's point in terms of the power of the people, because, when I talked about like a Magna Carta of human rights and having a conversation, I think that's very true. And I want to point to 1.5 successes or 1.5 areas at the EOC that changed dramatically in just a few years and sort of analyze why they changed. One is the whole issue of sexual orientation coverage under Title VII. When we started whispering about taking that position, we were accused of overreach. We were told not to go there. We were told that it was bad politics, that we would be, hammered by the Oversight Committee for taking that position. Now, after the Seventh Circuit decision in Hively, where you have Republican conservative judges such as Easterbrook and Posner basically following the position that we staked out several years earlier, you've seen a real sea change in this country. You've seen this sea change because it's happened one person at a time. You've seen corporations actually be on the cutting edge of issues of sexual orientation and inclusiveness because their employees have demanded it, right? Because their employees have demanded it. And you've seen this cut across partisan lines. And so now we're at a point where there are a couple more decisions coming down. The Second Circuit's going to consider, there's an amicus brief by 50 companies saying, look, the time is now, sexual orientation is covered by Title VII. It's viewed as good business, right? And this happened in the course of 5 or 6 years, right? It really did. The sea change happened in the course of 5 or 6 years in terms of this conversation, but the big piece of that puzzle was the people, okay, in the companies. The other one, to segue back to someone who was a friend of many of ours, Jacqueline Berrien, okay? When Jacqueline Berrien came to the EEOC, one of the things that as a chair, one of the things that she really pressed was the whole issue of addressing the discriminatory impact of arrest and conviction screens. And she was hauled up to Congress, okay? Chair Berrien, are you saying that you want child molesters to work in nursery schools? Okay, she was hammered. I mean, this was like the perfect storm of dog whistle politics. Jacqueline Berrien from the NAACP Legal Defense Fund, government overreach, disparate impact, race. It's all a witch's brew, right, of dog whistle politics. How could they resist not hauling our friend Jacqueline Berrien up there? And she stood there, and she was very poised and very much a person of faith, and she took this position because the words redemption were meaningful to her. And she stood there and she held her ground, and what you started to see over time is a new discussion in this country about reentry and about second chances. You started to see ban the box passed in red and blue states. You started to see, very conservative senators start to talk about criminal justice reform. Every time I would visit a law school, I would see Michelle Alexander's book because every single law student was reading that book. And you started to see this conversation, and you started to see a very critical look at the 80s and the 90s in terms of an understanding of the excesses of that period. And that happened one student at a time and one person at a time. And that happened because Jacqueline Berrien understood that this was a long game, right? That this was a long game. And now we're facing Jeff Sessions, who wants to roll back the clock on all of this stuff. you know, but still you have the young people, the law students who read Michelle Alexander, and you have the Republican state governors who signed the ban the box legislation, and it's probably too late to really turn back the clock on a lot of this stuff, regardless of what Jeff Sessions does. And this is sort of the power of the people.
Thank you. That's a good place to maybe stop for a minute. I could keep going, but I am going to stop because I'm getting that sign about the power of the people and the power of folks to make a difference. Are there questions from the audience? Oh, there are lots of questions. I think I saw this hand first here, right here.
Hello, my name is Amelia Hayden. I am a fellow with Respectability, and I'm a self-disability advocate. And I noticed a parallel amongst all the topics that you discussed on, particularly with EEOC, intersectionality, people of color. Now, my question for you is, with the ADA still being in its infancy compared to other statutes and other federal laws and mandated and compliance, as you have mentioned, how do we, as self-advocates, help our clients and our community keep up with the current times, since you mentioned that a lot of the employment field and sectors are going to this online, which is not accommodating under federal law, with such as people who are deaf, blind, have disabilities, and holding them accountable when, like as you brought up, with the asking questions that are adverse to the population, such as, for example, when you have a administrative secretary position, you don't have to drive. But when it requires you, in the wording, you required state-issued driver's license versus a state-issued ID. When they are making the requirements that are setting up preconceived biases for this population that are a violation under the ADA, but yet when we call in to agencies such as Equal Opportunity Employment to hold them accountable, it's, well, do you have any proof? Or, well, maybe they should find a job at a sheltered workshop. So my question for you is, we are more than able-bodied to do the job. How do we hold agencies accountable and teach our communities how to advocate for themselves, in a sense, because not everybody can afford an attorney, and as I'm seeing, not everyone knows their rights as required under ADA.
So one of the issues that we're spending a lot of time on is accessibility for individuals with disabilities. The ADA is not young. It's been around since 1991. It's more than 25 years old. You think by now we'd have a lot more equal access than what we do. We do a lot of testing and site surveys in that space and are still finding lots of problems in housing accessibility, in employment accessibility and accommodations, and public accommodations. And we're seeing also, as you said, things are moving online, so this issue of website accessibility, the ability of you to be able to go onto a website and be able to shop like everyone else. I mean, technology is a blessing and a curse. It could actually create more access if we actually push it to do that. And so taking testing and figuring out how to do it in this online universe is a priority for us. It's also important as we move to kind of this gig economy, because we used to have much larger institutions that we could try and hold accountable. Now a lot of those decisions are being decentralized. So how do we deal with those sorts of issues when we've got a very decentralized decision-making process now? And then to your point of making sure that people are educated, another piece we're looking at in really the tech space is how it is that we bring those communities together around those issues. So we're getting the education out there, but the communities are coalescing and educating each other, and also educating the ERC about where we ought to be deploying our resources in the accessibility space.
Can I just add one very concrete thing that folks can do is if they work for federal contractors, those contractors are required to include in their affirmative action plans any barriers to employment for people with disabilities, the work that they've done to address those barriers. So you can have a direct dialogue around that requirement that they all have to follow.
Great, thank you. Other questions? Yes, you had a question.
Paula Brantner, Workplace Fairness. Laura, you mentioned that people don't know about their civil rights laws, and at Workplace Fairness, we have a website to educate them about those. over 4 million people a year come to our website, and we find it's only limited by how many people Google will send us in SEO. But the EOC has to be reactive. You have to have a charging party. Lawyers have to have a plaintiff. So what do you see as the most important areas of the biggest opportunity for proactive work, pre-enforcement work? And a couple, what Melvina was talking about with testing, I think is very promising. Also, David didn't mention, but what the EOC is doing with sexual harassment. The standard is severe or pervasive, but by the time you're at severe or pervasive, you've already got a systemic problem that's very difficult to fix. So looking at ways to deal with a problem before it gets to the point that you need enforcement, you need litigation. What are some of the creative, proactive ways that we can harness the power of the people and organizations to get more involved?
So one thing I wanted to mention is there are several cities now that are working at the city level on this issue. So Boston is a great example. The Boston Women's Workforce Council is actually has almost 100 companies now and public employers and universities who signed on to their principles. They convene regularly. They share sort of best practices. They're creating a little community of accountability there. And that's a non-governmental solution that can be pretty powerful. You know, peer pressure matters.
I also think that there are lots of organizations that do online advocacy and some in-person advocacy. And there are groups like the Leadership Conference on Civil and Human Rights where you can bookmark them, they will send you emails, and they give, you know, average people opportunities to write their senator, to write agencies, to condemn sessions. I mean, the ACLU has an big online presence. Most organizations are moving a lot of their advocacy online. So I think if we expect to get our information about what's going on in the country with regard to civil rights and civil liberties from the newspapers and the radios and cable TV, we're going to miss a whole lot. So an informed public is a much more powerful public, and an informed individual is a much more powerful advocate. So I'd say, you know, building up your bank of online resources that will feed you accurate information would be really important.
Thank you. I know we have other questions, but we also are out of time. So I know some of the panelists will be able to stay after, a couple may have appointments. But please join me in thanking this really wonderful panel. Thank you all for being here.
Thank you.
And thank you for joining us.